On February 8, 2023, Michaela Johnson, then 17 years old, participated in an armed robbery that occurred shortly before 1 p.m. in San Antonio, Texas. The robbery involved a mother and her 4-year-old son, who were boxed in by multiple vehicles and held at gunpoint. Johnson was arrested along with 2 juvenile co-defendants and charged with aggravated robbery in the 175th Criminal District Court of Bexar County. On December 4, 2024, Johnson, now 18, entered a plea of no contest to the lesser-included offense of robbery, a second-degree felony under Texas Penal Code, Section 29.02, which carries a punishment range of 2 to 20 years in prison. Under the plea agreement, punishment was capped at 8 years. Defense attorney Patrick Hancock represented Johnson, while the Bexar County District Attorney's Office prosecuted the case. Today's hearing before Judge Catherine Torres-Stahl will determine whether Johnson receives deferred adjudication, community supervision, or is sentenced to prison.
Oh, that's okay. Who's here? Michaela Johnson. All right. Is that the person on the Samsung who's not dressed appropriately for court and appears not to have a shirt on?
That.
All right. So they will not be given a victim impact if that is the person. All right. And then there's someone on by the name of Bachelor Santabenes. All right. So then Samsung appears to be yours. So that person will not be given a victim impact.
Yes, sir.
All right. I think everyone should know that you have to have clothes on in court.
There she is.
Oh, well, he's at the end of the pile. All right. Court is calling 2023 CR 3848, State of Texas versus Michaela Johnson. Can I have parties announced for the record for the state? Defense.
Patrick Hancock for the defendant.
All right. And are you Ms. Johnson?
Yes, ma'am.
All right. We're here for sentencing. You entered a plea of no contest to robbery on December 4th. According to the plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposing your application for community supervision or deferred adjudication. They're taking certain items into consideration. All right. Did you all have a chance to review the PSI report, state?
Yes, Judge.
Defense?
I did, Your Honor.
Any objections to the PSI report, state?
No.
Defense?
No, ma'am.
All right. State, any witnesses?
No, Your Honor.
Defense, any witnesses?
Yes, Your Honor, I do. I have Miss Alicia Franklin, Michaela's mom.
All right, Ms. Franklin. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth, that nothing but the truth so help you God?
I do.
All right, you can lower your hand. Make sure you keep your voice up so the court reporter can hear. If you can state your name for the record.
Alicia Franklin.
All right, defense.
Miss Franklin, good morning.
Good morning.
You and I have spent a lot of time together regarding Michaela, is that correct?
Correct.
And you are aware that Michaela has accepted responsibility for a robbery here in Bexar County.
Correct.
And today is the day that the judge can either send her to prison or entertain her application for probation or deferred adjudication.
Correct.
Ms. Franklin, let me just ask you, how old is Michaela?
As of now, she is 18. When the case started, she was 17.
And when did she turn 18?
November 3rd.
And where is she a student at?
At Roosevelt High School.
What grade is she in?
She's a senior.
And being in Roosevelt High School, has she made future plans, applied to any universities, or done anything at this point in her senior year?
Yes, she was accepted to UTSA, and we're pending.
Excuse me, please whisper.
Say it again, ma'am.
She was accepted to UTSA, and we're pending the application for Clark Atlanta University.
Very good. And how is she doing in school?
She's doing good. She's on my honor roll. Right now she has all A's and perfect attendance since she's been out.
And did Michaela request a letter from one of her school counselors to offer to the court today?
She did.
Ron, I tendered this to the state for their review. at some point you'd like me to look at that, Judge.
All right, any objections to the court reviewing this? All right, you may continue.
Ms. Franklin, with regard to that letter, is it a positive review of how Michaela's doing at Roosevelt High School right now?
Before examining the mother's testimony, this courtroom moment deserves attention. A person appearing via Zoom without proper attire was barred from delivering a victim impact statement, demonstrating that courtroom decorum standards apply equally to virtual participants. Alicia Franklin's testimony reveals an unconventional parenting approach. After her daughter's arrest on serious felony charges, Franklin made a calculated decision to leave Johnson in the Behar County Jail for 5 months before posting bond, wanting her daughter to understand the gravity of the charges and experience incarceration firsthand as a deterrent. Under Texas Code of Criminal Procedure, Article 17.15, courts set bail based on multiple factors, including the offense nature, criminal history, and community danger. For second-degree felony robbery, bail often ranges from $15,000 to $50,000 or more. Franklin testified she had the financial means to post bond immediately but chose not to, allowing her daughter to experience nearly half a year in pretrial detention. Franklin testified that during those 5 months, Johnson developed a true meaning of what jail is. Since her release, Johnson has maintained perfect attendance at Roosevelt High School, earned all A's, and been accepted to the University of Texas at San Antonio. The testimony also revealed mental health concerns, depression, and low self-esteem, now being addressed through counseling, which becomes relevant because courts can consider mental health treatment when determining suitability for community supervision under Texas Code of Criminal Procedure, Article 4, 2A.301.
Judge, may we address the bond violation?
Yeah, just one moment. All right, so now the violation.
Judge, I'm trying to understand it. We got notice of it, and I think it went to Judge Angelini, and he remanded Michaela without bond, and she was picked up. So she was, as a result of this case, she was placed in alternative school through the school district. She goes to Roosevelt, and she was attending some school on Saturday. She completed her alternative school, was headed to her course on Saturday when she was notified that she did not have to go to school on Saturday.
And here they're complaining about a McDonald's.
Right. So Michaela can answer your direct questions, Judge, but in a nutshell, she thought she could use the time to go pick up food for her brothers and sisters through her father.
All right, and then what is this with Montage Apartments and Marshall's Meadows apartment?
Yes, ma'am. So
I'm gonna have to put you on there. Oh, State, are you prepared to proceed on this?
yes, Your Honor.
You have, you're asking that she remain remanded, or you all have discussed it?
So we discussed it. I think the state wanted to hear from her specifically as to what happened. And ultimately, I think we were going to be in agreement to allow her back on bond with the understanding that she's not to do these things. But we wanted to make sure this is actually what happened.
All right, can you raise your right hand? You solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Michaela Johnson.
Does anybody have any questions?
I'll ask Michaela a few questions if I may. Michaela, you've had a chance to read the violation report. You've explained it to me. I think there's some specific addresses that the judge was going to inquire about. So why don't you just explain to the judge what your decision was once you found out you did not have to attend school?
Yes, sir. Once I found that I didn't have to attend school, I had got a call from my little brother and little sister that they were hungry, and I thought I could use the time. So I went to the apartments to grab money from my aunt. And on the way back, I went to the apartments to ask them what they would like from McDonald's, which is why I was at the McDonald's. And I went back. My Uber took a little longer than expected, which is why I was late home.
Okay. Any questions?
No, Your Honor.
All right. Did her mom want to say anything to
No,
this?
Judge, I think we've addressed it. I just wanted you to know she has the support of her mom and is residing with her mom.
All right. And States?
So, Judge, I understand what happened in the violation report. It does seem like her story did make sense. That's why I wanted to make sure that the court was able to hear and make a decision based off of what happened. The state's primary concern, again, we heard all this through her attorney, but it's something that I just wanted to make sure, was this the actual thing?
that occurred, also to make sure that the court admonished her and made sure that this didn't happen again.
All right. So you're 17.
Yes, ma'am.
You have to realize when you're on GPS, you're only allowed to do what you're allowed to do.
Yes, ma'am, and I apologize.
So the proper thing to have done would have been to pick up the phone, call your pretrial services officer and say, I don't have school today. I just got a phone call from my siblings. They're hungry. May I go to McDonald's? And guess what? They're either going to say yes or no. When you're on GPS, it is not best to ask for forgiveness than permission. When you're on paper, everything is you got to ask for permission, not forgiveness. Because I think the previous judge taught you that asking for forgiveness after not asking for permission does not work in court. Do you understand that?
Yes, ma'am.
All
Judge,
right.
I think her mom had called Mitchell bail bonds and they would agree to get back on the original bonds if the court would consider that.
All right. If you will call Mitchell bail bonds, because I can't reinstate the bond unless Mitchell bail bonds tells the court they're okay with the court reinstating the bond. So if you get in touch with them today, what I will do is I'll ask that the bond will be reinstated and you'll have your previous GPS conditions and you're only allowed to go to school.
Yes, ma'am.
Do you understand?
Yes, ma'am.
All right. So that's not going to happen until I get notification from your counsel that Mitchell is willing to go back on your bond.
Yes, ma'am.
Can I firm that in, Judge?
Yeah, if you want to call them now, you can.
I'll do that.
You're an officer of the court.
All right.
All right. Thank you.
Judge.
Johnson's path to sentencing wasn't without complications. This footage from approximately 2 months before sentencing reveals the strict nature of pretrial supervision and the challenges young defendants face navigating these restrictions. Johnson had been placed in alternative school as a bond condition and was required to wear GPS monitoring, tracking her location at all times. On a Saturday, she completed her alternative school program and was informed she didn't need to attend regular class that day. When her younger siblings called saying they were hungry, Johnson visited her aunt at one apartment to get money, checked with her siblings at another apartment about their McDonald's order, picked up the food, and headed home. Her Uber took longer than expected and she was late. The GPS deviations triggered immediate arrest and she was remanded to custody without bond. Judge Torres-Stahl's admonishment was direct. When you're on GPS, you're only allowed to do what you're allowed to do. When you're on paper, everything is you got to ask for permission, not forgiveness. The judge reminded Johnson that a previous judge had already taught her this lesson. Under Texas Code of Criminal Procedure, Article 17.40, courts can impose any reasonable condition on pretrial release related to victim or community safety, including GPS monitoring, curfews, and location restrictions. These conditions are court orders, not suggestions. Any deviation, even for seemingly valid reasons like feeding siblings, constitutes a violation that can result in immediate arrest and bond revocation. Defendants must obtain advance permission from pretrial services before any schedule change, no matter how minor. The judge explained Johnson should have called her pretrial services officer and asked permission before going to McDonald's. Instead, by acting first and explaining later, she violated her release conditions. After hearing her explanation, the judge agreed to reinstate bond, but only after her bail bondsman confirmed willingness to continue guaranteeing her appearance. This incident demonstrates Johnson had already received a second chance after violating bond conditions, likely factoring into the court's later assessment of whether she could successfully complete years of probation supervision.
Were you aware that this offense occurred on February 8th of 2023?
Once I got a call from the Michaela when she was already in custody.
So you knew the date.
Yes,
And what day was that of the week? Do you remember?
I do not.
Would it surprise you that it was Wednesday?
I mean, I don't know. Did it surprise?
It was a Wednesday.
Yeah.
Would it surprise you that this offense occurred shortly before 1 p.m.?
The whole thing surprised me.
But I'm asking specifically about the time at which the offense occurred. Would that surprise you? Did you know that it happened?
I did know. I mean, I've known since by reading the papers, and
Where should Michaela have been?
she should have been at school.
So do you know, or did Michaela ever talk to you about what happened during this offense?
Yes,
So you were aware that the victims in this case was a mother and her young 4-year-old son.
yes, sir.
And you had a chance to read the victim impact statement.
Yes, sir.
And did it shock you that this had a drastic effect on that family?
No, sir. I definitely understand the turpitude of the case.
So you understand what the victim's feeling when she's saying that prison would be appropriate here.
I don't think it would be appropriate for Michaela
And ma'am,
for the simple fact.
I'm gonna ask if you could answer my question. Would it surprise you or does it shock you that the victim in this case is asking for prison?
No, sir.
Is it understandable?
It definitely is understandable.
And were you aware that the other two people that participated in this act, that they were both younger than you?
Yeah.
So she was the oldest one out of the group, right?
Okay. Yes.
So she should have been able to make better decisions than the other two, correct?
I don't agree with that. The other two had been in trouble. I understand, and she also was the only girl. So.
And specifically her role in this act, were you aware that she was the person that drove the car that boxed in the victim and her son?
I understand that she was the driver. Yes, sir.
Specifically that boxed in the victim and her
I
son.
understand.
Nothing else to say.
All right, any other questions?
The prosecutor's cross-examination established critical facts about Johnson's participation. The offense occurred on a Wednesday, shortly before 1:00 p.m., when Johnson should have been at school. Franklin acknowledged her daughter's absence from Roosevelt High School. That day was unauthorized. The prosecutor then focused on the victims and Johnson's specific role. Franklin confirmed she was aware the victims included a mother and her 4-year-old son. According to the prosecutor's questions, the mother told the perpetrators her young child was in the vehicle, yet the robbery continued. This detail becomes crucial when considering the psychological impact on both victims. Franklin also acknowledged Johnson, at 17, was the oldest of the 3 participants, with 2 younger juveniles involved. More significantly, the prosecutor established that according to case stipulations, Johnson was the driver of the vehicle that boxed in the victims, trapping them and enabling the armed robbery to proceed. Under Texas Penal Code, Section 29.02, robbery occurs when a person commits theft while intentionally or knowingly threatening or placing another in fear of imminent bodily injury or death. While Johnson did not personally display the firearm, her role as the driver who blocked the victim's escape route made her criminally responsible as a party to the offense.
This morning, Judge, I think her point on that is she was charged with aggravated robbery. She did not possess, hold, or yield a gun. And so it's been kind of a process of explaining that to her. So I think that she's not minimizing her role as far as doing things with those young men. However, I think she's made a distinction that contrary to what the state wants to put forward, is that she was not the leader of this. She was a follower in this, and she did not possess or hold a gun. So I think as to Miss Ballard's point in the PSI, maybe she could have gotten out of the car and said, "Hey, don't do that." She didn't do it. But the point of the matter is that she was in the car and not actively terrorizing these people. I make that distinction, but I also understand that if she's there, that she's a part of it.
All right, because I'm reading the PSI. I'm sorry, reading the stipulations. And the stipulations, it says that she was the one who boxed the driver in.
Well, Judge, we're here taking responsibility for the facts. So I don't think she has said that she's not guilty of this offense. I just think she has a different interpretation of her role versus those young men.
All right. All right. Anything else from the state?
I was informed by victim advocates that the witness on Zoom was dressed. It was a brown sweater. That's what she's saying that she was wearing.
No, the person who was on Samsung, that wasn't a brown sweater. Unless I'm colorblind or something's going on, they had on no top.
Well, all right, Judge. I just wanted to make sure.
All right. Thank you. All right.
I don't want to overstep, but I do want to make a brief argument this time.
Yes, you may proceed.
So Judge, when I first started representing this young lady, she was in jail. And as her mother said, usually I have to field those questions. How quickly can we get out of jail? I think Ms. Franklin took a very brave approach for a single mom. And that is that I want her to sit there. These are serious charges. I want her to get a taste of incarceration. I want her to understand that you have to be penalized or punished for the things that you do. So 5 months passed by. And so I think that the value in that here in the courtroom today is that she has a taste of incarceration. And I think she's come out of jail, Judge, and the letter from the Roosevelt High School from Ms. Howard says she's really doing well in school. It's hard for me to believe she's 17 years old when I met her and charged with such a serious crime, and she's turned 18 and she's only 3 months into her 18th year. So, Judge, it's one of those things. She's got a bright future. She's got hopefully acceptance into a school in Atlanta. She's been accepted to UTSA. Those letters, in my opinion, Judge, from Roosevelt High School, those are hard letters to get for the defense. And that's a really fine letter that supports Michaela in her application for probation. I don't want the court to think that she's minimizing this, because we've spent hours talking about the what ifs and how you can't find yourself in that situation. Her mom was bright enough through some talking that we had to get her sessions with Mark Harris. And Mr. Harris is very good through the juvenile probation and through private practice of bringing these young people in. He specializes in young offenders and working with them with this cognitive behavioral. You can't find yourself in the situation. You can't find yourself around the situation. If you do, then you need to leave. You don't need to be boxing anybody in cars. So I think this has been put square upon Michaela. I think she's done a great job out on bond. I think she's doing a great job in school right now.
Judge Torres-Stahl raised a concerning issue from the pre-sentence investigation report. Johnson appeared to be minimizing her role in the offense. The PSI documented that Johnson initially stated, "I have no comment," but later claimed, "I feel it needs to be looked into more," rather than what they are saying. Defense attorney Hancock attempted to clarify that Johnson's comments reflected a narrower dispute, distinguishing between being present at the robbery versus personally handling the firearm. Hancock acknowledged the legal reality. Under Texas law, physical possession of the weapon isn't required for robbery liability. If Johnson was present and participated in the criminal enterprise, she shares responsibility for all participants' actions. This distinction matters less legally than it might appear. Texas follows the law of parties, which holds accomplices equally responsible for criminal conduct of co-participants when acting with a common purpose. The fact that Johnson drove the blocking vehicle, enabling the armed robbery, makes her culpable regardless of who held the weapon. The defense's closing argument focused on rehabilitation rather than disputing guilt. Hancock emphasized Johnson's mother made the brave decision to leave her in jail for 5 months as punishment and deterrence. Johnson has thrived since release with perfect grades and college acceptance, and successful completion of deferred adjudication would allow Johnson to avoid a felony conviction while still being held accountable through years of probation supervision.
Judge, I just want to, you see more of these PSIs than I do, but it looks like the juvenile offenders who I think have the more serious role in this. I can't read this correctly, but it looks like one of them had his cases dismissed, maybe placed on probation, and then one was sent to some kind of TYC placement. So I guess if I look at that, Judge, I just argue that there will be some kind of equitable position here by the court to figure out what to do with Michaela. Again, Judge, deferred adjudication on second-degree felony is quite a good thing. I mean, we all know what deferred adjudication is, but sometimes it doesn't mean a do diddly damn in court. Here, it makes a big difference because it gives her a chance to prove herself, and it gives the court a long leash to make sure that she's doing well. I don't know what else we could bring the court to show that she's remorseful, doing well at home, doing well on her conditions of bond. So again, we would ask that the court wisely place her on deferred adjudication. Understand that she's done 5 hard months in the Bexar County Jail. I think she spoke about her fear of the jail with Mark Harris in that letter. I think her mom made a good decision, and we're hoping that will sway the court and giving her a chance at a future without being another young Black female with a conviction on her.
Here's the court's problem, and what I think people need to look at. Sometimes punishment, and all attorneys will tell you, when we're in law school, they tell you about the purposes of sentencing. Sometimes the purpose of sentence is for rehabilitation. Sometimes it's just punishment. Sometimes it's protecting the community. There are a whole host of reasons. But your problem is sometimes when you've done something that is considered so horrendous, right? No matter the changes you've made, sometimes it's just a prison offense. There are a lot of people who do things that I'm sure if they could go back in time, they would have changed it. They would have said, I wouldn't have done it. But the boxing of someone in with your vehicle, and I read the PSI report and I read the stipulations. In the stipulations, the driver of the vehicle said, hey, my son is in the car. And that didn't give anybody pause. I would think that there are certain things that should give people pause. For example, if somebody holds somebody at gunpoint and they want to steal their vehicle, they would say, oh my gosh, shucks, I didn't know there was a child in this car. Let me pause. But they gave nobody pause. Everybody just still continued with what they were going to do. That's a problem for the court. So this is what the court...
Isn't the problem that she was, no matter what her role was, it was still going to be something that was horrendous because it's a robbery.
Yeah.
So and I'm not trying to argue with the court, but under that circumstance, then no one should be eligible for deferred adjudication.
Well, counsel, as you're aware, there are different types of robbery. And there are some robberies that don't involve a child. State?
Your Honor, so right here, one thing I did notice in the letter for the psychiatrist, something that is bothered me, I've seen it somewhere in here, is that Ms. Johnson, she said she gave them a ride but did not know their intentions, but she played a role in boxing them in. She says that she had never had or handled a gun that night. When the police lit up her car, the boys threatened her if she didn't keep going. One of the boys threatened to shoot her if she stopped. Nowhere is that brought up in the report that she had mentioned that she had said that they had threatened her. So that's just something that is...
Well, I don't think it's her feeling. So it's not going to be in a police report.
Right.
But I can tell you that was her feeling on this. She did feel threatened by these 2 young juvenile offenders. But we're here today to take responsibility and not make excuses. So that's our answer to that, Judge.
All right. Is there anything else before the court makes its ruling?
No, Your Honor.
No, Your Honor.
All right, this is what the court is going to do. Court is going to find you guilty, taking consideration 2023 CR 3850, 2023 CR 3849, grand jury number 806632. There's to be restitution of $110 to John Bright in grand jury number 806632. Give you credit for any time served. I'm going to retain jurisdiction. Your attorney will tell you what that means, and I'm going to sentence you to 6 years in the prison. Did you review what it's entitled trial court certification with your attorney? Did you understand it, and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And Mr. Hancock, you can explain to her what that means.
I will, Judge.
The prosecution's response was direct. Johnson played an essential role by boxing in the victims, preventing their escape. The 4-year-old child has suffered lasting trauma from witnessing his mother held at gunpoint. The state argued that regardless of Johnson's post-arrest progress, prison was the appropriate consequence for terrorizing a mother and child in broad daylight. Defense attorney Hancock made one final equity argument. The 2 juvenile co-defendants, both younger than Johnson and arguably more culpable as the ones who actually wielded the firearm, received lesser punishments. One had charges dismissed and was placed on probation. The other was sent to a juvenile facility. The defense emphasized the value of deferred adjudication. Under Texas Code of Criminal Procedure, Article 4, 2.101, deferred adjudication allows a defendant to plead guilty or no contest, but the judge defers entering a finding of guilt. If the defendant successfully completes the probation period, up to 10 years for a felony, the case is dismissed without a conviction. This differs drastically from regular probation, where a conviction is entered immediately. The benefit is significant: no felony conviction on record, eligibility to eventually seal the record, and the ability to honestly answer no when asked about criminal convictions. However, the risk is equally significant. If probation is violated, the judge can impose any sentence within the full statutory range, 2 to 20 years for a second-degree felony. Judge Torres-Stahl delivered a sobering explanation of her sentencing philosophy. She noted that while punishment can serve many purposes, rehabilitation, deterrence, protecting the community, sometimes an offense is simply so serious that prison is the only appropriate response. The judge focused on a specific detail. When the victim told the perpetrators her young son was in the car, it gave no one pause. They continued with the robbery anyway. Judge Torres-Stahl found this particularly troubling, suggesting it demonstrated a level of callousness that warranted incarceration regardless of post-offense rehabilitation. The judge sentenced Johnson to 6 years in the Texas Department of Criminal Justice, granting credit for the 5 months already served in county jail. She retained jurisdiction over the case, allowing potential sentence modification based on Johnson's behavior and progress. Johnson's sentence reflects one of the most difficult tensions in criminal justice: how to balance a defendant's genuine rehabilitation efforts against the severity of the original offense and its impact on victims. By all accounts, Johnson made significant positive changes after her arrest. She addressed mental health issues, excelled academically, gained college acceptance, and appeared to take responsibility for her actions. Yet Judge Torres-Stahl's reasoning illustrates why good behavior after arrest doesn't always lead to leniency. The robbery involved elements courts view as particularly aggravating: targeting a parent with a young child present, continuing the offense even after learning a 4-year-old was in the vehicle, and using tactics that demonstrated planning and coordination. The victim's trauma, especially the lasting psychological impact on a child who witnessed his mother held at gunpoint, weighed heavily in the court's analysis. The GPS violation incident adds another dimension to understanding the court's decision. Even after being released on bond with strict conditions, Johnson deviated from those requirements. This pattern of boundary testing, however well-intentioned, likely reinforced the court's concerns about whether Johnson could successfully complete years of intensive probation supervision. The comparison to the juvenile co-defendants' outcomes raises legitimate questions about sentencing disparity. While those individuals received probation or juvenile facility placement, Johnson, as the oldest participant but arguably not the most culpable, received prison time. This disparity likely reflects the different systems at play. Juvenile justice focuses heavily on rehabilitation, while adult criminal courts must balance multiple sentencing objectives, including punishment and deterrence. The case demonstrates how Texas Penal Code Section 29.02 applies even to defendants who don't personally display weapons or make threats. Johnson's role as the driver who trapped the victims was legally sufficient to establish robbery liability. These moments remind us that constitutional rights are tested and defined not in abstract legal treatises, but in real courtrooms with real people facing real consequences. By examining these proceedings, we can better understand how the law works in practice and how the rights we take for granted are protected or challenged every day.